Yeah, this is the last attempt to do this today because it's been breaking up all the time. I've just changed the telephone provider in order to try to broadcast you without interruption. So this is a summation court report. The problem is that last week the channel was struck on Friday last week, so I wanted to report all week long on the court proceedings. But as you can imagine, with 5 days of court proceedings, I can't really sit and refer to all the notes in detail. Otherwise, it'll literally be hours and hours and hours of footage. So I'm really going to do a short summation. The trial has now ended in terms of representations. So the prosecution and the defence and the witnesses have all made their cases, and the jury retired late on Friday afternoon to consider their verdict. They only had a few minutes to basically elect someone who will be their foreman or whatever they call it, and to familiarise themselves with the environment which they'll be sitting to do their deliberations. Now, so I'm only going to pick a few elements of what happened and try to give you a feeling and a sense of what went on. And then I might well try to construct a more sophisticated video showing footage and material relating to the case at a later date. I've also got some overall material to put the entire thing in a bit of historical perspective for you. But the first thing to say is, in the end, I think the trial went quite well. There's this 4 people on trial, so I can't mention all their names because they don't want to all be mentioned. One of them is well known to you if you're involved in the movement against the anti-lockdown movement and so on, and that's Nacho. And then there's a guy called, I'm going to call it just by their initials, so it's AP, JD, AA, and Nacho. So they were 3 of them were represented by barristers. That's Nacho, JD, and AP. And AA, Adam A, he represented himself. He was accused of taking a baton from a police officer, possessing a baton, and attempting to take a baton off another police officer, which they said was basically assault. And all 4 of them are charged with violent disorder. And now, violent disorder is supposed to be you're in a group of 3 people who are engaged in a violent event, and they're all engaged at the same time in this violent event. And basically, this was the events of the 24th of April 2021 in Hyde Park. Now, in the proceedings, the barristers, of course, the judge is sitting there, the jury is sitting there, there's 12 of the jury, and the barristers stand up front presenting their case, and the accused are in a glass cubicle created, I presume, for coronavirus, and maintained ever since. And so it's quite difficult actually to hear them and to hear the proceedings if you're standing behind, if you're sitting behind them. And we're in the viewers gallery over here, but there's also people in the gallery behind the glass cage. During the proceedings, the police had quite a few witnesses. The witnesses for the police gave contradictory evidence. There was body-worn footage from the police. There was what they called open source footage from the internet. And then there was witness statements. Now, there was only one witness statement for the defence. I think that was a flaw on the part of the defendants. But in any case, that was a decision made by the barristers for the defence. And only Adam A, who represented himself, had a witness statement or a witness present to explain what happened. However, luckily for us, in my opinion, Adam A managed to get, on the last day of the trial, after all the witnesses had presented their cases, the prosecution had presented their case, the defence had presented their case, on the last day, Adam A managed to get the video of GB Resistance footage from the day presented to the court. We tried to get Banana Man's video shown, but unfortunately, because it had been cut, it was considered inadmissible, apart from a very small section at the fence towards the end of the events. Now, the advantage about showing GB Resistance's, or Resistance GB's footage, was that it was the only time that the jury were able to see what actually happened from the standpoint of those who were participating in the events, the protesters and the people surrounding the band at the end of the day. Because before that, it had always been presented, this band was playing in breach of coronavirus, and they were deliberately ignoring agreements that had been made, and they were breaking the park rules. And in the coronavirus legal actions, there was one legal action taken about the prohibition of the vigil in the Sarah Everard case, and the judges there said that unauthorised music events, the police had the right to go in and storm an unauthorised music event, so a sort of rave or something like that, they could just go and storm in. So the police tried to make out that from a protest movement, which had political, some kind of exemption to the regulations, the event in Hyde Park had become an unauthorised music event, and the unauthorised music event therefore was legitimate to close it down. There were a number of contradictory statements made by the police. For example, Chief Inspector O'Hara, who was appointed Chief Inspector, as I pointed out in one of the earlier videos after this event, he said that when he went into the crowd, his intention was to use the 4 E's, explain, the 4 E's anyway, the 4 E's, explain, educate, whatever, and then enforce only after 3 sort of discussion type level E's had been used, and then only then enforce. And he said that when he went into the crowd, he went in on one direction, expecting his officers to follow him in order to raise his megaphone. And there is, if you look at the scene by scene through Willsey's video, then you'll see there is this officer who's gone in there and tries to raise a megaphone, and he loses it at some stage. It's taken off him, or he loses it. But almost simultaneous with that, there is this scene of the police officer just barging through the people, and then people trying to protect the band, and tussles breaking out, and then the mood changes. The police are pushed back, and then all the events that become, are famous in this trial and are considered in this trial took place. Now, it was important to have that because it gave a lot of context to the jury, because it's the jury we're talking to. You see, the judge is sitting there. It's not like a magistrate's court where the judge makes a decision on what they think the law is and what they think happened. It's the jury that's important, because the judge gave instructions. You see, the judge gives what he calls directions, and the directions are on points of law, which, okay, if you're a barrister, you know all the legal, or you're supposed to know, pull up all the legal case law and statute law and so on, and refer to that when you make your arguments. But a direction from a judge in a case like this is to the jury, and the jury are lay people, and lay people don't have this familiarity with the law. So although someone who is in the jury, or people in the jury, can sit there and argue the legal parameters, again, they don't have all those references. They have only the reference that the judge gives them. So the judge will effectively instruct them. This is what the law says. If this person did this, then they must be found guilty. If they or they are guilty. If this person did this, then they're not guilty. Are you certain, as a, if you like, a reasonable member of the community, as someone just observing the events, that this person did this? So, for example, Adam A takes a baton from a police officer. Are you certain that the baton he was found with afterwards was the baton that was taken from the police officer? Now, Adam A said it was. So you'd think that this means, because the directions say so, that the jury have to say, well, he said it was, he took it, you can see him take it, therefore he must be guilty of possessing this weapon from the police. So you'd think it was an open and closed case, but actually it's not quite as simple as that. A jury are free to decide what to do themselves, and there are 12 members of this jury, and of them 10 are required to, well, the objective for now, like the judge has sent them away on Friday, yesterday, and the objective for now is to get a unanimous verdict. So all 12 must agree that this is the case, that they committed these offences in order to be found guilty. And if they don't get a unanimous verdict, the judge can accept a majority verdict. And a majority verdict in this case means 10 out of 12 must agree. Now, if it were just a case of barristers arguing their case with a judge, the barristers remain within the parameters of the court etiquette, if you like, and the court dynamics. And so they argue case law and so on. They find the minuity on which the legal parameters are set, and try to push against the boundaries of the minuity of those characteristics. So, for example, one of the barristers argued on behalf of JD, for example, that on behalf of Nacho, that the events were taking place at different times. So I may be wrong, it might be JD, at different times. So one thing happened, for example, the police went into the crowd. Second thing happened, the crowd pushed them back. Third thing happened, bottles were thrown. Fourth thing happened, the crowd moved following the police. Fifth thing happened, at the fence. And so there were different events taking place, and different people played different roles during those events. So nobody's disputing that bottles were thrown. None of the people who are on trial, in this case, are accused of having thrown bottles. One of them, his initials are AP. AP is accused of having thrown a tub of hummus towards the police, which now it's disputed whether it actually hit a police officer. Now the video isn't quite clear. The video, the footage that there's an open source video which shows him throwing this tub. The lid comes off it, and it's got red hummus in it. And of course the prosecution argued that he picked it up from the floor. He didn't know if it was hummus or not. It could have been anything. And he says he could have chosen a bottle if he wanted to, but he didn't choose a bottle. But he nevertheless threw something at a police officer, causing fear and alarm. And, it could have been anything in that tub. And that was one little amusing point was that the barrister said, in defence of AP, said throwing a tub of pepper hummus has to be the most middle-class act of violent protest ever known, if it is such a violent protest. There was another extremely amusing incident where JD's a beefy guy. He does a lot of working out. He's bulky. He's stocky. He looks quite mean, you know, and he's a very working class lad. And he was accused of having kicked a police officer in the testicles, and he was arrested early in the morning one day, taken to the police station after having appeared in the Daily Mail. And the prosecution tried to get him based on the fact that his demeanour, she had a number of photographs, for example, where he's going like this, and she said, "What were you doing with that demeanour?" Like with a freeze frame or a photograph, which is just purely, ridiculous. You can take a photograph, you can take individual snaps of me here. I'm about to attack someone, and then he was accused of having said to the police officers, it was pretty much inaudible, but he said he admitted in the end when he heard it that he did say that, but I wouldn't have admitted it because I don't think it was very clearly audible at all. And he said he's going like this and up to the police and he's saying, hit me. And then he's accused of having taken his bag off and given another bag to his mate. And that apparently is a threatening violence by taking your bag off. That was also an argument of the prosecution. And then he was going like this and like that to the police. It's on a police camera. And the prosecution again said, "What exactly were you doing there? What was that sign? What were you doing with your finger? What was that about?" Really, really harassing the guy on the dock. And he was like I said, a Cockney lad. He was giving it back and he said, "What do you mean? What was I doing? What was I doing? What do you mean, what was I doing?" He goes, "I was exercising my finger. And it was, we couldn't help but laughing. And then, of course, the judge, all these silly thing they got in their head and all that, he goes, "Can the gallery be silent? Stop playing to the crowd, to the gallery," and all this sort of thing. So it was an amusing moment, And there were a couple of amusing moments in this case, in the case of JD. And it turned out that the police officer who accused JD of kicking him in the balls didn't have any footage of it, and he alleged that the footage showed him kicking him in the balls, but all it did was someone was holding the guy's arm. He made a step forward to hold his balance, and that knee, they focused on his knee or on his thigh and tried to make out that was him kicking the officer, but then it was shown that the officer didn't bend down, didn't react at all, and there was no evidence that he had kicked the officer in the testicles. Then there was the case of Nacho. In the case of Nacho tipped off the hat of, he tried to tip off the hat of one WPC, and then he tipped off the hat of a PC, and his glasses fell off, and the PC said Nacho punched him directly in the face. Out of nowhere, came forward and punched him directly on the nose. And it reminded him, then when cross-questioned, he said it reminded him of having been punched. But the video clearly showed that he wasn't punched, and it was a flick to the hat. It did somehow knock the glasses off as well. And then the police officer took the picture and stop the frame like that. And the police officer's like this, his glasses coming off, and he's like this. Nacho's hand is up there, and the hat's come off. And the barrister for the prosecution then says that is he's blinking because he's been hit. Well, anything comes into your face like that, you're going to blink. And in any case, people blink all the time. If you freeze frame on this video, you'll see me blinking quite a lot. People blink all the time. So it's an absurd allegation. But the prosecution barrister was really trying to every tiny little thing they tried to grab on. In the case of AP, it must be said his response to the questioning was a little bit stilted, and the consequence of that was that the barrister for the prosecution tried to make a big deal out of the fact that he had not answered questions when arrested. So he got arrested one day, I think a month or so later, and when he got taken to the police station, he got legal representation, and the legal representation told him, give no comment. And the barrister literally stood him there in the dock and said, when you were asked, did you throw something, you said no comment. When you were asked, and just went through all the questions that he was asked about no comment. So what they call this is like a negative inference. So you have the right to remain silent, but if you rely on court something that you were asked and you had the chance to answer before, that might be held against you. So that was the argument that they were basically using, which was kind of made everyone wince. Why are you doing this? And if she'd done it once or twice, okay, but she just did it again and again and again and again and again. You said no comment, and this was said, and you said no comment. This was said, and you said no comment. This was said, and you said no comment. It went on for about 20 minutes. Quite bizarre. But in any case, then. So let's come on to the crux then. There were two very strong arguments made. One was an argument made in the defence by one was made by the barrister, and the other was the star performer of the day was AA. Now AA did a stunning performance. I mean, at the beginning of the trial, he was, he's got no training in law, and he had no reason to know how to deal with things. And at the beginning, it did look like he was in a bit of trouble. And I said to him, you do want to get a barrister, because, you could get real bother from this. And we don't know what's going to happen yet. But and the judge had already been mean to him at the beginning. And so it looked like this is not going to go well for him. But he rose to the occasion. And I must say that on the last day of the trial, it was a stunning performance. So, but I'll come on to that in a minute. Let's deal first with the barrister. The barrister, on behalf of AP, made a very good presentation, it must be said. His presentation was, he brought up the issue about the context of the situation. He brought up the issue of the Sarah Everard events, and the jury's mostly women, and quite young women, a few of them. And he brought up that and said, you got to remember, this was the circle. Take your mind back to where we were at that time. We're not asking you to agree with what the sentiments of these people are, but take your mind back to the atmosphere at the time, what was going on. And he did very well in that, I must say. He did very well. And he also did very well in pointing out, using the video again from Willsey, which was only shown at the request of AA that morning. He managed to explain that and show that it was the police who barged in and started. The point was the violence, the pushing. I mean, it wasn't extreme violence, but they were pushing their way in to a crowd and compressing people together. And there were people at the front. There were a number of women at the front who were being knocked over or pushed over or hard in between other people. And it was a dangerous situation. Someone could have been knocked out, fallen over, even killed in theory by a crush, by certain types of reactions and so on. And so he made very good points about this. Peculiarly enough, just as a sideline, on the issue of the bottles being thrown, not everyone picked up on everything that happened in the trial, but Nacho, for example, just before he was arrested, and he was charged with one, shoving a police officer with his arm, which you can visually see he did, trying to tip a police officer's hat on top, tipping another one's hat off and glasses off, for which he was accused of punching in the face, as I said. But just before that, there is a video which shows that he's hit by a bottle, actually. It's a plastic bottle, and he doesn't even notice it. So when people were throwing a plastic bottle with a bit of water in it, is not going to harm you. I mean, if it's full to the brim and it hits you in the head, of course it's going to stun you a bit if it's thrown with significant force. But if it lands anywhere on your normal body, it wouldn't be. If it hits you on the head, you would notice it. And of course, none of us are supportive of those who threw glass bottles at the police. It was whoever did that was foolish. Or as was implied by a number of people and also stated by people to me personally, could have been agent provocateurs or police. Now, sorry, anything else on the barrister? I won't go on too much about the other barrister, actually, because even though his arguments were good, they were within the parameters of all this stuff. He was basically contextualising it as saying, in the circumstances, this is really not that serious a series of offences committed by these individuals, who have, two of them have admitted that they did what they did, but are saying, got carried away, was a bit of a childish thing to do, knocked a policeman's hat off, thrown a hummus tub, I was angry, and chucked it towards the police. I didn't really have any specific aim, and it wasn't a heavy object in any case, and the police officer didn't notice it. So that's the parameters which were argued. But then came our hero of the court case, to be honest with you, and that's AA. And AA made some quite stunning contributions to the court case. He didn't try to deny his charges against him. Instead of this, what he did was he tried to break down the entire coronavirus story. He said at the beginning of the events he believed what was happening. Then in July he saw a video on YouTube by Rainer Fulmich talking about the PCR tests and questioning them. He laid down the credential of this individual in terms of his court case against Volkswagen on emissions, the emissions scandal, which led to the recall of, I think, 1 million vehicles or something like that. And then he became convinced. He said, I became convinced of what you might call conspiracy theory. So he was appealing to the psychology. He was trying to enter the heads of the jury to explain to them why he was in the position he was in. Then he said he went to a demonstration in the summer of 2020, which was attacked by the police, and to subsequent demonstrations. His employer told him that if he goes on any further demonstrations against the coronavirus regulations, that he would be sacked. And he resigned within an hour of being told this. And after that time, he attended various events. And then in analysing what happened, he went through, on the last day of the trial again, he called up some video footage from police officers, which followed the police officers out of the park. For example, one of the police officers who he disarmed, and another police officer who was slightly injured. He gets them coming together with their video footage on, and he gets them saying, right, one of them says, it's not an exact quotation, but it's as I noted it down at the time. One of them says to the other, I knew it. This was after the event, so when they got to their vans and the conflict had finished. I knew it. I said it was going to happen. And the other one said, that was the most stupid plan ever. So too, and then he had another one who said something very similar, and that was accepted by the judge, that he heard that, and the argument had been that he had tried to construct an argument at the very beginning, which wasn't very clear, but it came together at the very end, which was that there were in Whitehall 75 police officers who were given the task of protecting Downing Street, Parliament, and the rest of it. They were sort of crack troops of the police force, which Adam A implied or stated could be people with military training or even members of the military. Their task was to prevent the demonstrators, who were cited by the court, and sort of the general agreement was that the numbers of people were about, or at least 20,000. Now, there may have been many more than that, but the point was the court had sort of agreed this, and it come to a sort of acceptable that this is at least this many people were there. And so these 75 officers had been given the task of protecting Parliament, Downing Street, the key buildings in central London, and if necessary, Scotland Yard. And so these were sort of crack troops of the British police. and they had been moved by the underground bunker command in Lambeth to Grosvenor Square. Now, Grosvenor Square is, I mean, I know Grosvenor Square because I'm at Speaker's Corner every week, so I'm familiar with it. You can walk to Grosvenor Square from Speaker's Corner within 4 minutes, and you could run there within about 2.5. So they slightly got that wrong. They said about 10 minutes, but 2.5 to 4 minutes, I would think. And if they came by van, like with sirens on, they could be there in less time than that. And so there were 75 crack troops of the British police, top-notch trained officers, just around the corner. Not only that, but when the police left, so let's say this is the area where the band was playing. So this is north. This is where the band was playing. There's a Speaker's Corner Cafe is here. We were encircling the band. This is where the police attacked. The conflict broke out here, and there's an exit to the park over here. One exit with a gate, fence going right the way back here. There's 100 meters here. The fence is here. So the police, when they were retreating, they went past the exit that is directly in front of them here, right the way back over here. And actually in September 2020, there had been a conflict where the police were forced out of here. And so, but Grosvenor Square is over here. So there were 75 police officers, crack police officers, waiting to come in, been prepared just in case the conflict broke out to a larger scale. So in effect, what Adam A was arguing was that somebody at the higher levels of command, tucked away in Lambeth, with a couple of officers, 2 or 3 officers, who he made this specific allegation. He said, well, I believe this is what the case is. And he showed that one of the officers had had happened to be on holiday for 3 weeks at exactly the time when this trial was going on. And he happened to have no body worn camera on the day. And he also showed that there were communications between the command centre in the bunker and certain officers, but other officers not. Now, it appears from what Adam A said, and he believed this was the case, and he stated so himself, he was trying to work out forensically who had done what within the police. And it was a brilliant job he did. It was a proper Columbo job he had done. He was identifying individual officers, and he said, at the beginning, I thought it was Chief Inspector O'Hara, who, as I said in earlier broadcasts, I said he was promoted after this event. But O'Hara seems to have been almost like the fall guy, but for taking the fall, perhaps he was advanced. He went in, he believed he was pursuing the 4Es. He said to the court, and it's true that when you saw him talking, there was a certain believability to it. And Adam A said, I thought this guy was responsible, but as he was in the court and I cross-examined him, and he was cross-examined by others, I became convinced that he hadn't. And he had said he went in and he tried to speak. Now, there's a very peculiar thing here. He said he went in and tried to, and he addressed the crowd momentarily, and then his megaphone was taken off him. And he believed he was in charge, and he believed the officers would follow him, but the officers didn't follow him, and the officers had somehow got in their brain, because a number have testified to that effect, that they were there to seize the equipment and that they were at the enforcement stage. Now, how can the person in charge of the operation go in independently and try to speak to the crowd, or think he was trying to speak to the crowd, and yet, oh no, he wasn't able to address the crowd, he said, but another officer said he did hear him address the crowd. But anyway, these sort of things can happen, it's true. You can get sort of mixed memories. But the police, so there were clearly different instructions, and the barristers took that up as well, different instructions and different understanding of what was going on. Some police officers definitely had in their brain that they were going in there to seize equipment. And this ties in with the thing about, which Adam A was pointing out, was there may have been a plan, which he was trying to expose, to go in and cause a conflict, and that plan then was known by some of the officers, but not the others, and instructed to some of the officers, but not the leading officer on the case on the ground. So, he did a marvellous job in trying to expose at least the parameters of how this works. He wasn't able to prove it, and he stated to the court, I can't prove this is the case, but something is very fishy going on here. Some foul play, something is rotten in the house of Denmark, as they say, I think. And it was this component that I thought was very strong. He tried to construct the story as well as he could. He pointed out those officers who he thought were not involved. He pointed out the contradictions in the arguments shown by police footage about what they had done and who was instructed to what, and whether the police officers knew. I mean, all of them said, oh, no, we weren't told any plan. But the fact that we had audio of the officers talking to each other privately after the event saying that plan was a disaster, basically, and I knew that was going to happen. And these were injured officers, by the way. That is a very strong piece of evidence, in my opinion, and it was exposing what they did. And of course, the jury's sitting there looking like, like this is a detective show, like, are they Sherlock Holmes, who's figuring it out? And yes, Adam A. wasn't able to prove this, but he certainly was able to cast doubt, and doubt is the essence of what it's about in the decision of the jury. And then he said, well, okay, and he had said, he had admitted what he'd done. He basically said, I was confiscating the batons from the police who could have used them violently, and were intending to use them, and did use them violently against a number of people. It was also interesting because on Willsie's video, one of the people who was praised as a hero, a guy who was quite drunk actually, he had a little cuffs, and the judge kept saying, this guy with cuffs and a collar and I think it was a blue jacket, he was trying to stop the violence, a hero, they sort of described him as semi-heroes. And then there was a guy called the Icelandic guy, they call him. He's a big beefy guy with like crops on the side, and he stood at the beginning and sort of tried to stop things. Unfortunately, we weren't able to use Bannerman or Banana Man's video, where he turns around at the very end and he addresses the police and says, we were here for peace and love, and you turn it into violence. And I thought, real shame that we didn't get that in, but in any case, we weren't able to because of the way in which the video was edited, and we didn't request it in advance to be able to get the raw footage. But in any case, the point was made already with this other guy, and the judge noted it himself, which I found, to be fair to the judge, in his summation, he did present the different arguments quite accurately, and he did even, he didn't have to do that. So I think he whatever reason is behind that, the judge actually didn't do a bad presentation of the summation of the case. But this guy who had intervened, there's video of him on Willsie's footage being pushed over by a policeman onto the floor, and still he goes out and tries to halt the violence. And then later on, they didn't mention this, but if the jury looked through it carefully, they might notice. And some of the jury were like very, very careful notes. They're studiously trying to analyze, play their role, some of them. And this guy was whacked by a police officer with a truncheon. So he had clearly done nothing wrong, but he was whacked by a police officer. So I hope the jury click onto that. Then at the end of Adam A's appeal to the jury, he made a tremendous statement. He basically said, well, look, you, in this country, you are sovereign in this court. So even though, basically, he didn't say that, but even though I've admitted I'm guilty of the offences that I've been charged with, you can decide to acquit me. He didn't say it in those words. He said, you are sovereign. You can decide what happens. You don't have to take instruction. You don't have to, listen. If you think what was wrong or what happened was wrong, if you think the police were to blame, and if you think there might be a chance that this was all done by some people in senior command, and he also pointed out that one of the officers who had bleeding down his head took a couple of selfies. Now, there was a reasonable explanation for that. You take a selfie because you want to show the injury contemporary, when it happens, you want to show the injury before they clean it up. But it's also true that the Daily Mail suddenly appeared. Now, the Daily Mail had not been at the event earlier. They had not broadcast anything about the event. And suddenly there were Daily Mail reporters snapping this guy. And then it was all over the Daily Mail. So it was reasonable to impute that there was there might have been some collaboration involved in this. And I've personally had experience of the National Union of Journalists collaborating with the police in order to try and take my press card off me. So I think I'll leave it at that. I mean, the jury have gone away to consider their verdict. They will probably spend all day on, I mean, ideally, it would be good for us if the jury are unable to decide what to do on Monday, because that means they're heading towards what they hope would be a majority verdict, and which may well not be a majority at all. They may not be able to agree on a verdict, in which case they are not guilty. And that's our hope, that on Monday all charges will be dropped against them. It's an outside chance, because primarily, as I said, because of Adam A's speech, where he literally appealed to them. And you got to figure, if amongst the jury some of them had injuries from medical interventions which happened recently, or their family members had injuries from medical interventions, or they were sympathetic to questioning what happened in British society and around the world over the last few years, there's a chance that they'll just turn around and say, I'm not going to go along with this. And Adam A said, if a member of the royal family was on trial here, you have the right to say that they're guilty or not guilty, regardless of anything else. You can decide. And he basically said, you have the sovereign power. And that was he made a very, very good speech. I can't replicate it because we're not in the court, and I don't remember the exact words, but it was a great presentation. And it's very important in cases like this, where you have a number of people on trial simultaneously, to have some kind of division of labour, where you have some people who are barristers and present the legal spiegel stuff, and some people who are, or one or two people who will stand up and defend themselves from the heart, defending their cause, explaining their cause. And then I think you can win the jury over, or at least neutralise enough of the jury, 25% of the jury in this case, to get a not guilty verdict. Let's see what happens on Monday and possibly Tuesday. If you can come down to the court and show some solidarity, that would obviously be appreciated. But the chances are on Monday that there will be not much happening till they deliberated. It could be by the afternoon, but I doubt it. There's a lot of video footage to go through, lots of arguments been put to them. I can't see them deciding on Monday, but it's possible. If not, then Tuesday, and if Tuesday, the likelihood of either a majority or a not guilty is there. So that's the case. I just wanted to point out something to you quickly. We think modern times, video, all that sort of thing, which is what we've got. We've got a lot of video footage, but I'm a Speaker's Corner buff, basically, and I've studied the history of Speaker's Corner, how Speaker's Corner came about, how the right to free speech came about, how the right to vote came about, how the right to strike, demonstrate, protest, and so on all came about. And one day I was looking on, I think it was eBay, but it might have been Abe Books, and I found this available on the internet. And what it is, I'll show it to you here. This is a report of the commissioners. And it's called The Disturbances in Hyde Park. And you see the dates here. The session, it was a session at the of the commissioners authorised by Parliament from the 31st of January to the 29th of July 1856. They held sessions where they invited about 80 police officers and about 80 members of the public to be witnesses as to what happened in Hyde Park in 1855 at a demonstration. And at this demonstration, so I'll just read you a couple of tiny bits just quickly, just so you understand what happened and why we have Speaker's Corner, why we have this right to protest, and how we fought for it and what happened. And yes, there was violence to achieve it. And yes, we battled to achieve it. And let me just contextualise this for you as well. 1854, there was a cholera epidemic in London. And the establishment, the sort of conservative establishment, and by I mean small c, the sort of elite, the aristocracy and so on, those who live in big houses in the countryside and their allies, they believed and implied that the working classes in dense living conditions and working conditions, who often got drunk and lived dissolute lives, were responsible for the cholera epidemic. And their drunkenness was largely a component of this. And so what they did was they passed a law called the Beer Bill and the Sunday Trading Bill. And basically workers were paid on Saturday night. So if they weren't able to go shopping on Sunday, they had nothing to eat and nothing to drink. It was very difficult circumstances for them. Whereas, of course, the wealthy people, they had their own staff go out and buy for them whenever they wanted, and they had large supplies of alcohol whenever they wanted as well. And so they actually imposed something very similar to the tier system, and they banned people from drinking in London. And you had to go out to Richmond to go and get drunk, or to go and get a beer on a Sunday. And so they had there was an investigation into that, which was one thing, and then they found that lots of workers were getting on the train to go to Richmond, because Richmond was outside the tier area, in order to drink, and they had banned drinking in London. So not everything is new, in this world. Anyway, then the workers protested in Hyde Park against this. Let me just read a couple of little bits out for you, just to give you a little bit of historical perspective. So, to the Queen's most excellent Majesty, may it please your Majesty, we, the commissioners appointed by your Majesty's letters patent under the Great Seal bearing the date of 14th of July in the 19th year of your reign, and commanded to inquire into an alleged disturbance of the public peace on Sunday, the 1st of July, 1855, in Hyde Park and the adjoining streets. By the way, just preceding this protest, there was also the defeat of the Charge of the Light Brigade, and also the Crimean War, in which Britain was involved, and large numbers of ordinary soldiers suffered and died, and of course we were fighting Russia as we are now, and there were 86 witnesses on the part of the complainants. Basically, one barrister represented one person who was taken into custody, and they had to try and find witnesses who were involved, and 93 on the part of the police, a full report of whose evidence is annexed. Here is the evidence from an investigation into the events in Hyde Park in 1855. They made the effort. You have to say that they made more effort than has been made by the establishment in Britain, because they have all these crooks who gather all this stuff and present it to you in a neat document. This was raw interviews with people from all around, from different professions, where they lived. Minutes of the evidence here starts at page 3 and continues up until page 546. And the appendix has a list of all the different people who were interviewed, their names, where they lived, what their profession is, what happened, where they were seen, where they were arrested, and so on and so forth. And an interesting phenomena here the people protesting on the 24th of June and then on the 1st of July, I believe it was. They assembled in Hyde Park. A large multitude assembled in Hyde Park on the spot indicated on the north bank of the Serpentine. The crowd shouted and hooted and yelled at carriages. The rich people went in their carriages there, made such noises to frighten the horses in the drive, to the annoyance of danger of those on horseback and in carriages. Annoyance and danger of those. The interruption naturally caused alarm and prevented many carriages from driving at that direction. An attempt was made by some persons to organise a meeting and address the crowd, but they were required to desist and stopped by the police. In the course of the following week, handbills were distributed and placards exhibited, calculated to attract people to Hyde Park on the next Sunday. It was stated on one of these that at Hyde Park, the open-air fete and monster concert would be repeated on Sunday next. In another, let us go to church with Lord Robert Grosvenor next Sunday morning. We can attend his lordship in Park Lane at 10:30. Go to church with him and then go home to dinner and be back in time to see our friends in Hyde Park. The police superintendents have an amusing approach to the whole idea of protest. Join the elite. Let's go to their celebration. And a very interesting part. Let me just see if I can find it here. They say there were also a mixture of thieves, pickpockets and other reckless, disorderly persons bent on plunder and mischief and seeking to effect their purposes under the shield of popular excitement. Then comes a very interesting piece. I hope I can find it. Yeah, here. This is perhaps the most interesting bit of all, which sort of associates with what we've seen on our protests over the last couple of years. Soon after 7 o'clock in the evening, some young soldiers of the guards who had mingled with a portion of the crowd seemed disposed to take part in the tumult. Information of this was brought to Superintendent Hughes, who sent to the magazine barracks, and a sergeant was dispatched with a picket to bring in the soldiers. Some stones were thrown by the crowd at the sergeant and his party while engaged in the performance of his duty, and the crowd followed after the soldiers to the barracks and remained there throwing stones. The sergeant in command then sent in his turn to the police for assistance, which was promptly rendered. One of the offenders who had hit a soldier with a stone was given into custody and afterwards fined, and this crowd was dispersed without any unnecessary violence. About 9 o'clock in the evening, the park was cleaned by Superintendent Hughes, with a body of about 100 policemen formed an open line with 2 or 3 yards between each man, extending northwards from the Serpentine and advancing eastwards towards Hyde Park Corner and Stanthorpe Gate. The operation seems to have been effected successfully. So, history repeats itself, first as a tragedy, then as a farce. Thanks very much, ladies and gentlemen. I'll be reporting again either on Monday or Tuesday, depending on the timing of the trial results. And as a consequence of the strike last week, it's unlikely we'll be doing many streams. Streams will move somewhere else, and I'll identify that and let you all know where those will be. But otherwise, most things will be pre-recorded in future, because most of the sort of events, because it seems that YouTube seem determined to prevent people from having live discussions about issues of the day, and so some other platforms will have to be used for that. Thanks very much for following the discussions.